Hey, thanks for tuning in to the Anarcho podcast. In this episode and the episodes to follow, I will return to my roots, namely reading books from great libertarian philosophers. When I started the podcast, I was reading The Anatomy of the State by Rothbard, The Ethics of Liberty by Rothbard, What Has Government Done to Our Money by Rothbard, and The Virtue of Selfishness by Ayn Rand. Then I did a bunch of episodes that were not based on books, but where I was giving my thoughts and having conversations with other like-minded people. But now I think it's time to read yet another book. This book has been very influential in my own thinking about the libertarian philosophy, and I think it's a must-read for all who call themselves libertarian or anarchists, because it really covers an issue that has not gotten so much attention in the libertarian canon. There is a lot of thought that was spent on political philosophy, such as The Ethics of Liberty by Murray Rothbard. But this book is kind of a hidden gem. So if you have never heard of it, I think it's a great read, or for you, I guess, a great listen, and something you definitely should be aware of. The arguments presented are very strong and they need to be grappled with. For me personally, it was very influential, like I said, and it has significantly changed how I view the world, most specifically the world of software. For anybody who has been aware of my podcast, I'm a very big fan of the cypherpunk ethos that aims to change the world through creating technologies that are unstoppable, that allow individuals who use them to become sovereign. And I think, the backbone for all of this philosophy is also somewhat rooted in the arguments that are put forth in this book, or at least they are heavily backed up by the arguments. So what is the book? The book is called Against Intellectual Property by Stefan Kinsella, as you may have gleaned from the title of this podcast. And Stefan has actually been on this podcast before. I will link in the show notes the episode I did with him. And for a long time, I've wanted to read this book to my audience and discuss the ideas put forth in it. So far, I didn't get around to it, and now I think is better than never. So we will read Against Intellectual Property. We will discuss the ideas, and as with any of my episodes, if you want to chime into the conversation, you can go to my website, alexanarcho.live, or if you want to reward me for making this content, you can go to xmrchat.com/alexanarcho and leave a little tip with Monero XMR. It would be greatly appreciated. Also, if you helped fund this episode, then you are eligible to join a secret Discord, a secret Matrix society on the Matrix Messenger. For this, you have to go to my website and claim your transaction. And when claiming the transaction in the form, you simply provide your Matrix username. And this will, the bot will send you an invite then to the group. Let's dive in. Against Intellectual Property. Property rights, tangible and intangible. All libertarians favor property rights and agree that property rights include rights in tangible resources. These resources include immovables, realty, such as land and houses, and movables, such as chairs, clubs, cars, and clocks. So I think this is a brilliant distinction, and the word tangible may be somewhat foreign, but it means exactly what was described here. Basically, in my mind, it's things that you can touch. So I can walk up to a house and touch the house. I can walk up to a chair and touch the chair. And so things that exist in the real world. And for those things, libertarian philosophy puts forth the idea of property rights, that these tangible commodities, tangible goods can have a rightful owner. And I think this is something that we'll come back to every now and again, that this is pretty a clear-cut issue and there's not a lot of discussion on this. Basically, from John Locke on, the idea of being able to homestead land is very deeply interwoven in libertarian philosophy. All right, let's continue. Further, all libertarians support rights in one's own body. Such rights may be called self-ownership, as long as one keeps in mind that there is dispute about whether such body ownership is alienable in the same way that rights in homesteadable external objects are alienable. So alienable means you can kind of outsource them or give them away to somebody else. And I think what he's referring to here is the discussion that, for example, Walter Block and Murray Rothbard had. I mean, Rothbard has passed away. But the idea, can you sell yourself into slavery? And for this, I will actually read the footnote, which reads, debate over this issue manifests itself in differences over the issue of inalienability and with respect to the law of contract, i.e., can we sell or alienate our bodies in the same manner that we can alienate title to homesteaded property? For our arguments against body inalienability, see Stefan Kinsella. Here. A theory of contracts, binding promises, title transfers, and inalienability. Hard word. So, for example, as I understand it, Rothbard says that you cannot sell yourself into slavery. Like, your will is inalienable, and therefore you cannot, like in perpetuity, sell your will to your own body. And Walter Block is of a different opinion, as I understand it, and say, well, yes, you can do that. So there is some dispute in that regard, but I guess the common ground is that we do agree that we own our own body. Yeah, so this is the most immediate thing that we have in the world. If we think back to in the Ethics of Liberty, Rothbard explains the scenario of Robinson Crusoe being stranded on his deserted island, and the immediate reality he's faced with is the possession and property of his own body. That, like, he can control his own body, and he kind of also has to sustain his body in order to keep on living. All right, let's continue. In any event, libertarians universally hold that all tangible scarce resources, whether homesteadable or created, immovable or movable, or our very bodies, are subject to rightful control or ownership by specified individuals. Yeah, so we'll not get lost in the discussion of can you sell yourself into slavery for this episode, but we'll just surf on the wave of agreement in libertarian circles that, yes, you can have these property rights in tangible, scarce resources. And I think with texts like these, it's really important to measure every word. So tangible means things you can touch, and scarce means that there is a limited amount of them. And the whole idea of property rights is because of the scarcity aspect. If things were abundant and you could have like press a magic button and things would just appear out of thin air, property rights wouldn't really make a whole lot of sense. The purpose of property rights is to reduce conflict that we can have over these scarce resources. Namely, well, can I sleep in this particular bed, or is that your bed to sleep in? So in order not for us to bash our heads in, we come up with the idea of property rights, which then gives us a clear guideline to establish who can now sleep in that bed. And yeah, all right. Also, what I want to point out is that the ownership is by individuals. Yeah, so not a collective. Just an interesting side note. Let's continue. As we move away from the tangible, corporeal toward the intangible, matters become fuzzier. Rights to reputations, defamation laws, and against blackmail, for example, are rights in very intangible types of things. Most, though not all, libertarians oppose laws against blackmail, and many oppose the idea of a right to one's reputation. And I think Rothbard made this argument also in The Ethics of Liberty, that what is my reputation? Is that something that I own? Well, no, not really. My reputation is your estimation of me that you hold in your own head. And I mean, do I now have a right over some of your thinking about me? No. Because here the immediate self-ownership of one's own body and thereby mind is, very much takes precedent, I would say, over the idea of a reputation. And Rothbard in Ethics of Liberty put this, like he followed this very logically. So he was like, okay, blackmail, it's not criminal in the sense of the libertarian philosophy, because blackmail just means that I offer to kind of hold my tongue in exchange for some payment. And so the classic example would be, I see my neighbor who cheats on his wife. Now I approach my neighbor and I say, oh, I saw you cheating there. If you don't want me blabbering to your wife, you now have to make payments to me. And again, what's the situation with property rights there? Does my neighbor have property rights over knowledge or information that I hold in my own head? And if not, then it's totally legal for me to offer a contract to not disseminate this information to the world. And again, here Kinsella makes the point that there is some disagreement, but I myself definitely fall into the camp of Rothbard here, that it's pretty clear to me. Like you have some information in your head and you can do with that information whatever you want. Let's continue. Also disputed is the concept of intellectual property, herein referred to as IP. Yeah, so IP not in the sense of internet protocol, but intellectual property. We'll keep that in mind. Are there individual rights to one's intellectual creations, such as inventions or written works? Should the legal system protect such rights? Below I summarize current US law on intellectual property rights. I then survey various libertarian views on IP rights and present what I consider the proper view. All right. So obviously we live in a world with intellectual property rights. This is a very big industry. We have a lot of things like patents and trademarks and copyright and whatever. And this presents that the illusion, okay, we do have intellectual property. And as you may guess from the title of the book, Kinsella does not really agree with this. But nevertheless, it's not such an easy topic, or it's more nuanced. Yeah, so let's really dive into what the current state of IP, intellectual property laws are. And we'll focus on the case of the US for this because, of course, Kinsella is a US citizen. So now we dive into the summary of IP law. Types of IP. Intellectual property is a broad concept that covers several types of legally recognized rights arising from some type of intellectual creativity or that are otherwise related to ideas. IP rights are rights to intangible things, to ideas, as expressed copyrights, or are embodied in a practical implementation, patents. Tom Palmer puts it this way, quote, intellectual property rights are rights in ideal objects, which are distinguished from the material substrata in which they are instantiated, end quote. In today's legal systems, IP typically includes at least copyrights, trademarks, patents, and trade secrets. Now here our distinction from the beginning becomes important again. We have this tangibility aspect to some things that exist in the physical world that we can touch, and intellectual property now tries to expand this concept of property rights to intangible things. So to something like an idea. And of course you cannot touch an idea, you cannot kill an idea. And this is the basic distinction between normal property rights or property rights in physical tangible goods and in intangible things. Copyright. Copyright is a right given to authors of original works, such as books, articles, movies, and computer programs. Copyright gives the exclusive right to reproduce the work, prepare derivative works, or to perform or present the work publicly. Copyrights protect only the form or expression of ideas, not the underlying ideas themselves. While a copyright may be registered to obtain legal advantages, a copyright need not be registered to exist. Rather, a copyright comes into existence automatically the moment the work is fixed in a tangible medium of expression and lasts for the life of the author plus 70 years or for a total of 95 years in cases in which the employer owns the copyright. So I think to most on the internet, the idea of copyright is familiar. This can, if you have, for example, these streamers who watch other streamers' streams and react to them or don't react to them, this can be copyright struck. Or if you are re-uploading music of an author on YouTube, you may also be copyright struck. And so this is a broad concept on the internet that if you are using the works of somebody else, then you may get a copyright strike and some legal trouble may ensue. And I think the important thing here is to differentiate that, of course, if now I have a original idea, rare as that may be, the idea itself is not protected. It's just like I write a book on an idea and now my book, the expression of this idea is covered by copyright. And it's also interesting to note that how long this copyright lasts, for 95 years in cases in which the employer owns the copyright. So a very long time. Patent. A patent is a property right in inventions, that is, in devices or processes that perform a useful function. A new or improved mousetrap is an example of a type of device which may be patented. A patent effectively grants the inventor a limited monopoly on the manufacture, use, or sale of the invention. However, a patent actually only grants to the patentee the right to exclude, i.e., to prevent others from practicing the patented invention. It does not actually grant to the patentee the right to use the patented invention. Not every, and I think before we continue, this is a very important distinction. So the government comes in and grants you a monopoly on some invention or process, and you now can go to the government if you find your neighbor is using the same thing and say, well, they are violating my property right of the patent that I have filed with you. And now you, dear government, are forced, or the government gladly forces then the neighbor to not use that invention or process. So you have the right to exclude your neighbor from the invention or process. All right, let's continue. Not every innovation or discovery is patentable. The US Supreme Court has, for example, identified 3 categories of subject matter that are unpatentable, namely laws of nature, natural phenomena, and abstract ideas. Reducing abstract ideas to some type of practical application, i.e., a useful, concrete, and tangible result, is patentable, however. US patents since June 8, 1995 last from the date of issuance until 20 years from the original filing date of the patent application. The previous term was 17 years from date of issue. So patents are much shorter lived than copyright, and there are some cases in which a thing, or not really thing, an idea is not patentable under the US Supreme Court. Trade secret. A trade secret consists of any confidential formula, device, or piece of information which gives its holder a competitive advantage so long as it remains secret. An example would be the formula for Coca-Cola. Trade secrets can include information that is not novel enough to be subject to patent protection or not original enough to be protected by copyright. Example, a database of seismic data or customer lists. Trade secret laws are used to prevent misappropriations of the trade secret or to award damages for such misappropriations. Trade secrets are protected under state law, although recent federal law has been enacted to prevent theft of trade secrets. I think the example of Coca-Cola drives this really home. Yeah, so the formula for our dear Coca-Cola beverage is not something that is protected by a patent or a copyright, and instead how they keep it secret is by reducing the people that know about it and contracting with the people who know about it to not divulge that information. Trade secrets protection is obtained by declaring that the details of a subject are secret. The trade secret theoretically may last indefinitely, although disclosure, reverse engineering, and independent invention may destroy it. Trade secrets can protect secret information and processes, example, compilations of data and maps not protectable by copyright, and also be used to protect software source code not disclosed and not otherwise protectable by a patent. One disadvantage of relying on trade secret protection is that a competitor who independently invents the subject of another's trade secret can obtain a patent on the device or process and actually prevent the original inventor, the trade secret holder, from using the invention. Also very interesting. So let's imagine Coca-Cola has the secret recipe and I'm totally obsessed like Captain Ahab and I want to recreate this formula. Theoretically, I could now in my basement brew one elixir after another until finally I have landed on the exact formula for Coca-Cola. And in this case, there is nothing Coca-Cola can do. I did this with my own property and I was under no contract to refrain from doing that. As Kinsella points out here, now if I, as the original inventor, opted on purpose not to pursue a patent on this invention of mine that I just kept secret, the second inventor, who is maybe less morally inclined, can then go to the government and patent my invention, or I guess they invented it too, and then once they have obtained the patent, exclude me as the original inventor from using my invention. Trademark. A trademark is a word, phrase, symbol, or design used to identify the source of goods or services sold and to distinguish them from the goods or services of others. For example, the Coca-Cola mark and the design that appears on their soft drink cans identifies them as products of that company, distinguishing them from competitors such as Pepsi. Trademark law primarily prevents competitors from infringing upon the trademark, i.e., using confusingly similar marks to identify their own good and services. Unlike copyrights and patents, trademark rights can last indefinitely if the owner continues to use the mark. The term of a federal trademark registration lasts 10 years, with 10-year renewal terms being available. Yeah, so from the secret formula of Coca-Cola, we now move to their iconic font that you most definitely know from all of their sugary beverages. And this is now subject to a different kind of intellectual property, namely a trademark. And of course, Coca-Cola can prolong their trademark, because otherwise there probably wouldn't be a Coca-Cola company if it expired at some point. So they have to kind of like renewing your Netflix subscription. They renew their federal trademark registration subscription every 10 years. The other rights related to trademark protection include rights against trademark dilution, certain forms of cyber squatting, and various unfair competition claims. IP also includes recent legal innovations such as the mask work protection available for semiconductor integrated circuits designs, the sui generis protection similar to copyright for boat hull designs, and the proposed sui generis right in databases or collections of information. In the United States, federal law almost exclusively governs copyrights and patents, since the Constitution grants Congress the power to promote the progress of science and useful arts. Despite the federal source of patents and copyrights, various related aspects, such as ownership of patents, are based on state law, which nevertheless tend to be fairly uniform from state to state. Federal trademarks, by contrast, not being explicitly authorized in the Constitution, are based on the Interstate Commerce Clause and thus only covers marks for goods and services in interstate commerce. State trademarks still exist since they have not been completely preempted by federal law, but federal marks tend to be more commercially important and powerful. Trade secrets are generally protected under state, not federal law. So interesting distinction here again for me. This goes kind of into the weeds of US legal frameworks. What's state law? Yeah, so is it a law of Ohio or Illinois, or is it a law of these United States, of the federal government encompassing all of the states? So there are some differences here, but I think we don't have to dive deeper into this. Many laymen, including libertarians, have a poor understanding of IP concepts and law, and often confuse copyrights, trademarks, and patents. It is widely and incorrectly believed that in the US system, the inventor who first files at the patent office has priority over those who file later. However, the US system is actually a first to invent system, unlike most other countries which have a first to file system for priority. The point I want to take home here is that we shan't not be confused by intellectual property. If we are to oppose intellectual property, we ought to understand what is actually encompassed by it. And so throwing everything in the same bucket, the copyrights, the trademarks, the patents, is really doing us a disservice, and we should know the landscape, i.e. the legal landscape here in the US, to have an opinion on it. And fortunately, Kinsella has written this very good book in helping us understand this landscape. IP rights and relation to tangible property. As noted above, IP rights, at least for patents and copyrights, may be considered rights in ideal objects. It is important to point out that ownership of an idea or ideal object effectively gives the IP owners a property right in every physical embodiment of that work or invention. Consider a copyrighted book. Copyright holder A has a right to the underlying ideal object of which the book is but one example. The copyright system gives A the right in the very pattern of words in the book. Therefore, by implication, A has a right to every tangible instantiation or embodiment of the book, i.e. a right in every physical version of the book, or at least to every book within the jurisdiction of legal system that recognizes the copyright. Thus, if A writes a novel, he has a copyright in this work. If he sells a physical copy of the novel to B in book form, then B owns only that one physical copy of the novel. B does not own the novel itself and is not entitled to make a copy of the novel, even using his own paper and ink. Thus, even if B owns the material property of paper and printing press, he cannot use his own property to create another copy of A's book. Only A has the right to copy the book, hence copyright. I think copyright for me is one of the most interesting aspects of intellectual property, and I mean, maybe you can already glean some of the absurdity that follow if we try to apply this concept of copyright idea. I mean, having the property right of the idea of the book, kind of like in this Platonian sense, yeah. So Platon with his example of the cave, that we are all strapped down in the cave and we're just looking at shadows being cast on the cave wall by a fire that is behind us. And then in the ideal world, there is the embodiment of the novel, I don't know, For Whom the Bell Tolls, or what other work you may have. And that the author, the Ernest Hemingway in this example of For Whom the Bell Tolls, would then have the property right of that ideal form, and thereby also the right to be the only one who can create copies of it. Likewise, A's ownership of a patent gives him the right to prevent a third party from using or practicing the patented invention, even if the third party only uses his own property. In this way, A's ownership of ideal rights give him some degree of control, ownership, over the tangible property of innumerable others. Patent and copyrights invariably transfer partial ownership of tangible property from its natural owners to the innovators, inventors, and artists. And that's where I'm going to leave off the reading for today's episode. But maybe you can already kind of begin to see, and maybe that's a good exercise before listening to the next episode, to try to square that circle, that property rights, or intellectual property rights to be exact, kind of seem to conflict with the property rights that we had already established in the libertarian sphere. So what I always like to do is to come back to the example of Robinson Crusoe on his island, and then later on Friday joins. So we can kind of simulate a economy of peers, of human beings that presumably have the same kinds of rights, i.e. that they own themselves and they can homestead the land on which they live and which they find like provided by nature, so untouched resources. They mix their labor with the soil and gain ownership over that land, that apple tree, that fish that they pull out of the sea or whatever. And now this idea of intellectual property rights enters the picture, and let's do the example. So we have Robinson living on one side of the island and Friday on the other. And let's suppose, for the sake of argument, there's also a state on the island who enforces intellectual property. And now Robinson tries to invent like a fishing net to be able to catch fish better. And he does. And Friday, also completely on his own, invents the same thing. Friday then goes to the state and patents his invention. And one day he sees Robinson using the fishnet that he came up with and he patented. And then he goes to the state and says, well, Robinson is using my intellectual property. And the state then goes to Robinson and says, you can't do that. We take that net away from you, and maybe you go to jail a little bit, or you have to pay restitution to Friday, whatever. Even though Robinson made that net completely by himself, he gathered the rope used for it himself, and all of that is completely in accordance with the homestead principle. And now, we come to this conundrum. I mean, of course, the example of Friday and Robinson seems somewhat contrived, but it really isolates the important stuff when it comes to things like property rights, to political philosophy, because it simplifies the world and we are left with the essence of it. So, this is the circle that now we seemingly have to square, because intellectual property rights do exist. And I mean, sure, like I could theoretically, I could come up with the works of Harry Potter or some other novel, and then all by myself. I mean, it's very unlikely, but given the length of the universe, it could happen. But J.K. Rowling could then come knocking down my door with the fist of the state and say, no, I actually own that idea of Harry Potter and whatever. So, I think this is a great setup. It was somewhat legal deep dive into what kinds of intellectual property we have in the US today. Let's just recap. So we have the copyrights. These are things like music, like books or whatever. Then we have patents. Patents are for inventions and processes or devices. And then we have trade secrets, which are not really per se enforced by the state. They can presumably also exist on a free market. And this could be the formula to Coca-Cola. And then we have trademarks. This could be the branding of some company, the font that Coca-Cola uses, and whatsoever. Good. And I also want to give you this homework to kind of start thinking about how this applies now to the cypherpunk landscape. I mean, Kinsella already hinted at it, that this concept of intellectual property and namely copyright can also apply to code. So I think in the United States, code is treated as free speech. In other words, it doesn't really matter whether I write a program in C or whether I write Harry Potter. It's basically same thing, bunch of characters on either a piece of paper or on a computer screen. But as we learned, it's not the physical instantiation of that idea. It's the abstract idea that counts for copyrights. And of course, this comes to great effect in our modern technological world where a lot of things are governed by code. So this is where I'm going to leave you. I hope you had fun listening to the first two chapters of Against Intellectual Property. If you like this, make sure to go to my website, alexanarcho.live, or leave me a tip in XMR Monero on xmrchat.com/alexanarcho. You can find more information in the show notes. You can find the book there. You can find the website of Stefan Kinsella. And I'm looking forward to our next episode, where we will then dive into the libertarian perspectives on intellectual property. Because we will see that there are many different perspectives in the libertarian niche, kind of on how you can grapple with these ideas.